Hello everyone, welcome to the channel. Now we have reached to Article 32, which is also known as the heart and soul of the Constitution. It was asked to Dr. B.R. Ambedkar about it, and he said, if I was asked to name any particular article in this Constitution as the most important one, an article without which the Constitution would be a nullity, I could not refer any other article except this one. It is the very soul of the Constitution and the very heart of it. This article makes the Supreme Court both the guarantor and defender of the fundamental rights. So, Article 32, as we read, is the title Remedies for Enforcement of Rights Conferred by this Part. Clause 1. The right to move Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. Clause 2. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. The writ of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. So, clause 3, without prejudice to the powers conferred on the Supreme Court by clauses 1 and 2, Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercised by the Supreme Court under clause 2. Clause 4. The rights guaranteed by this article shall not be suspended except as otherwise provided by this Constitution. So, Article 32 of the Constitution deals with the right to constitutional remedies or affirms the right to move to the Supreme Court by appropriate proceeding for the enforcement of the rights conferred by Part 3 of the Constitution. It means that if any of the fundamental right is violated, a person can directly approach the Supreme Court under Article 32. During the Constituent Assembly debates in December 1948, a discussion on this fundamental right was going on, and Dr. P.R. Ambedkar had said, if I was asked to name any particular article in this Constitution as the most important one, an article without which this Constitution would be a nullity, I could not refer to any other article except this one. It is the very soul and heart of the Constitution. This article makes the Supreme Court both the guarantor and the defender of the fundamental rights. Article 32, Clause 2 empowers the Supreme Court to issue directions or orders or writs, including the writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the fundamental rights in a given case. These writs, borrowed from English law, are known as prerogative writs. Prerogative. It's prerogative. Article 32, Clause 3 states that the Parliament is authorized to empower by law any other court to exercise within the local limits of its jurisdiction any of the powers exercisable by the Supreme Court under Clause 2. The word any other courts could only mean, it is written here, the word any other court could only mean any court rather than other than court under Clause 2. High Court, because High Court has already been vested with the such powers in Article 226. I remember. The Supreme Court's jurisdiction, Article 32, is original but not exclusive. It is concurrent with the jurisdiction of the High Court under Article 226. Article 32, Clause 4 states that the right to move the Supreme Court for the enforcement of the fundamental rights cannot be suspended except as provided by the Constitution. It is only under Article 358 where Article 19 is automatically suspended in emergency on the grounds of war and external aggression, and Article 359 that the Constitution empowers the President to suspend the enforcement of fundamental rights when a proclamation of emergency under Article 352 is in operation. Article 32 is a part of basic structure. Article 32 is an important and integral part of the basic structure of the Constitution in Skill Lotto Solutions versus Union of India, AIR 2021. A three-judge bench of Supreme Court consisting of Justice Ashok Bhushan, R. Subhash Reddy, and M. R. Shah stated that Article 32 is an important and integral part of the basic structure of the Constitution. Article 32 is meant to ensure observance of rule of law. Article 32 provides for the enforcement of the fundamental rights, which is the most potent weapon. It is the guaranteed remedy. In Ramesh Thapar versus State of Madras, AIR 1950, the Supreme Court observed that Article 32 provides a guaranteed remedy for the enforcement of fundamental rights. The court also observed that this court is thus constituted as the protector and guarantor of the fundamental rights, and it cannot, consistently with the responsibility so laid upon it, refuse to entertain applications seeking protection against infringement of such rights. About jurisdictions, the Supreme Court of India can issue the following types of writs in a given case. Number one, the habeas corpus. The literal meaning of habeas corpus is you may have the body, and this writ is important for personal liberty. The main purpose of this writ is to seek relief from the unlawful detention of an individual. It may be issued against a private person or the state. In ADM Jabalpur versus Shivkant Shukla, AIR 1976, a five-judge bench consisting of Justice A.N. Ray, the then CJI, M.H. Beg, Y.V. Chandrachud, P.N. Bhagwati, and H.R. Khanna of the Supreme Court in majority of 4:1 held that no person has any locus standi to move any writ petition under Article 226 before a High Court for habeas corpus or any other writ or order or direction to challenge the legality of an order detention during emergency. However, Justice H.R. Khanna, in his dissenting judgment, held that invoking Article 359, Clause 1 does not take away the right of an individual to approach the court for implementation of statutory rights. He further added to this and stated that during emergency, Article 21 only loses the procedural power, but the substantive power of this article is very fundamental, and the state does not have the power to deprive any of his life and liberty without the authority of law. This case is popularly known as the habeas corpus case. This judgment has been recently overruled by the Supreme Court in case of Justice K.S. Puttaswamy versus Union of India, year 2017, the Aadhaar card case. Second rate is the Mandamus. The literal meaning of Mandamus is weak command. It is issued by a court commanding a lower court or public authority to perform its official duties correctly. It may be issued against any public body or a corporation, an inferior court, a tribunal, or government itself. However, it cannot be issued against a private individual or body to enforce contractual obligations not arising from any statute. It can be issued to a direct public official not to implement a law which is unconstitutional. This writ is thus both positive as well as negative. This writ is also known as the judicial remedy. In Hari Krishna Mandir Trust versus State of Maharashtra, AIA 2020, the division bench of the Supreme Court, consisting of Indra Banerjee and Indu Malhotra justices, has held that courts are duty bound to issue a writ of mandamus for enforcement of public duty. Third writ, quo warranto, as you can read about it here. Quo warranto, the literal meaning of quo warranto is by what authority or warrant. It is issued by the court against the person who usurps a public office. The writ can be issued to inquire into the legality of usurpation of public office by such a person. The grounds on which this writ can be issued are that the public office is created by a statute or constitution of India and the person is to be appointed by a statute. However, this writ cannot be issued against a minister of private office. When Quo Warranto would lie, it was said in Rajesh Avasthi versus Nandlal Jaiswal 2013. The Supreme Court observed that a writ of Quo Warranto will lie when the appointment is made contrary to the statutory provisions. It was further held that the suitability of the candidate for appointment does not fall within the realm of writ of Quo Warranto. Fourth, the writ of prohibition. The literal meaning of prohibition is to prohibit it. This writ is issued primarily to prevent an inferior court or tribunal from exceeding its jurisdiction or acting contrary to the rules of natural justice. Prohibition is a writ of right, not a writ of course, and is of preventive nature rather than corrective. Writ 5, certiorari. The literal meaning of certiorari is to be certified. The main object of this writ is to keep inferior courts, judicial and quasi-judicial authorities within their limits of jurisdiction, and if they act in excess of their jurisdiction, this decision will be quashed by the High Court or Supreme Court by issuing a writ of certiorari. Lord Atkin stated that writ of certiorari may be issued whenever any body of persons having legal authority to determine questions affecting the rights of subjects and having the duty to act judicially act in excess of their legal authority. So the distinction between certiorari and prohibition is that the writ of prohibition is available at an earlier stage, whereas the writ of certiorari is available at a later stage on similar grounds. Writ of prohibition is used to prohibit the inferior court from exceeding its jurisdiction, and certiorari is used to quash the decision of an inferior court on the ground of want of jurisdiction. In Hari Vishnu Kamath versus Ahmad Ishaq, AIR 1955, the Supreme Court held that writ of prohibition will lie when the proceedings are pending to a large extent, and the writ of certiorari will be issued when the case has been terminated in a final decision. The Supreme Court further clarified that where the proceedings of inferior court are partly within the jurisdiction and partly without it, then the writ of prohibition will lie to the extent of excess of jurisdiction. While exercising the jurisdiction granted under Article 32, the Supreme Court has to observe the following principles. Firstly, the principle of res judicata. The students of Civil Procedure Code would clearly understand it. The reference res judicata, Article Section 11 of CPC. Res judicata is a principle in its own which states that if in the Supreme Court case of Daryao versus State of Uttar Pradesh, AIR 1961, if the matter has been adjudicated before the court, then it should not be agitated again. Res judicata will apply only when the matter was decided on merits. If the decision has been given not on merits but otherwise, then the decision will not operate as res judicata. Habeas corpus is an exception to the rule of res judicata. Hence, anyone can file a writ petition of habeas corpus again and again. Second, second principle, epistolary jurisdiction. Acting on letters written by or on behalf of the oppressed people is a strategy adopted by Supreme Court for facilitating access to justice. This is known as epistolary jurisdiction. The letters have been converted into writ petitions on the logic that Article 32 of the Constitution does not say as to who shall have the right to move the Supreme Court, or nor does it say by what proceedings. Appropriate proceedings refer to the purpose of enforcing fundamental right and not to the form how the court has been approached. The expression appropriate proceedings is too wide, and so moving the court through a letter can be an appropriate proceeding because it would not be right to accept a person acting pro bono to bear expenses from his pocket for having a regular writ petition prepared by a lawyer. Taking a clue from American Supreme Court decision in Gideon versus Wainwright, CIA 1963, where a postcard from a prisoner was treated as a petition, the Supreme Court adopted the innovative method to provide justice, liberalized the rule of locus standi, and treated the latter as a writ. This innovation represents the fact that the rules of the procedure of the court are to aid the administration of justice, to advance the cause of justice. If there is any conflict between the law of procedure and substantive rights of the parties, the latter prevails. The latter, which is the substantive rights of the parties, will prevail as the ultimate end of law is justice. Thirdly, the principle of doctrine of laches. In Trilokchand Motichand versus H.B. Munshi, IR 1970, the Supreme Court said first that there can be no upper or lower limit of time for filing petition under Article 32, but inordinate delay will not be condoned by the court unless and until there is sufficient reason for delay. Secondly, it was stated in Trilokchand Motichand versus H.B. Munshi that Limitation Act does not apply to writ proceedings. Fourth principle, the rule of locus standi. Generally, if your right is infringed and you are aggrieved, then you will go to the court. But in Article 32, the rule is different, and especially in habeas corpus petition, that even a friend or relative could file a case. Further, in case of PIL, that is public interest litigation, even a public spirited person whose right is not infringed can file a case on this point. SP Gupta versus Union of India, AIA 1982, is a very famous case. In this case, the Supreme Court of India defined the term public interest litigation in the Indian context. In Holy Cow Pictures Private Limited versus Premchand Mishra, AIA 2008, the Supreme Court made an important observation regarding PILs and stated that courts are flooded with a large number of PILs. So it is desirable for courts to filter out frivolous petitions and dismiss them with the costs. It was ordered by the Supreme Court that PIL has become a tool to empower themselves, not to empower themselves, but to gain publicity. So when the court was flooded with large number of PILs, it was important for the court to filter out the frivolous petitions. And sorry for my pronunciation about that. Article 32 was repealed, and Article 32A was repealed, and Article 33, power of Parliament to modify the rights conferred by this part in their application to forces, etc. Parliament may, by law, determine to what extent any of the rights conferred by this part shall, in their application to A. The members of the armed forces, or B. The members of the forces charged with the maintenance of public order, or C. Persons employed in any bureau or other organization established by the state for purposes of intelligence or counterintelligence, or D. Persons employed in or in connection with the telecommunication communication systems set up for the purposes of any force, bureau, or organization referred to in clauses A to C be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of discipline among them. Article 34. Um, about Article 33, firstly. Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces. Article 33. Sorry. Um, Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agency, and analogous forces. The object of this provision is to ensure the proper discharge of their duties and maintenance of discipline among them. This power to make law is exercisable by Parliament alone. Such acts cannot be challenged in any court on the ground of contravention of any of the fundamental rights. Now we should reach to Article 34. Restriction on rights conferred by this part while martial law is in force of any area. Notwithstanding any in the foregoing provision of this part, Parliament may by law indemnify any person in the service of the Union or of a state or any other person in respect of any act done by him in connection with the maintenance or restoration of order in any area within the territory of India where martial law was in force or validate any sentence passed, punishment inflicted, forfeiture, ordered, or other act done under martial law in such area. So Article 34 provides for the restrictions on fundamental rights while martial law is in force. It empowers the Parliament to indemnify any person in respect of acts done by him in connection with the maintenance or restoration of order in any area within the territory of India where martial law was enforced. And secondly, to validate any sentence passed, punishment inflicted, forfeiture ordered, or other acts done under martial law in such area. Reaching up to Article 35, the last fundamental right available to us, the legislation to give effect to the provisions of this part. Notwithstanding anything in this constitution, A. Parliament shall have, and the legislature of the state shall not have power to make laws. First, with respect to any of the matters which under Clause 3 of Article 16, Clause 3 of Article 32, Article 33, and Article 34 may be provided for by law made by Parliament, and second, for prescribing punishment for those acts which are declared to be offences under this part. Thirdly, and Parliament shall, as soon as may be after the commencement of this Constitution, make laws for prescribing punishment for the acts referred to in subclause second. B. Any law in force immediately before the commencement of this Constitution in the territory of India with respect to any of the matters referred to in clause 1, subclause 1 of clause A for or providing for punishment for any act referred to in subclause 2 of that clause shall, subject to the terms thereof and to any adaptations and modifications that may be made under therein under Article 372, continue in force until altered or repealed or amended by the Parliament. Explanation of this act is that in this article the expression law in force has the same meaning as in Article 372. Article 35 lays down that the power to make laws to give effect to certain specified fundamental rights shall vest only in the Parliament and not in the state. This is to ensure uniformity throughout India with regard to the nature of those fundamental rights and punishment for their infringement. This is the end of all our fundamental rights, Article 12 to Article 35, Part 3 of our Constitution.